Swayam Prabha. Digital India. Educated India.
Hello friends, welcome to lecture number 10 of our course on law of copyright, patent, trademark and other IP. We have started discussing patent law. In the last lecture, I discussed about the patentability criteria. If you recall, we said there are three criteria which an invention has to pass: novelty, and novelty is absolute novelty which we have in Patent Act. We compared the invention with the prior art to see whether the invention is new or not. The second criteria we discussed was inventive step. Inventive step has to be examined from the standpoint of a reasonably skilled man in that art, whether the invention is obvious for him or not. And when we examine it in the context of closest prior art. I also told you about the difference between prior art, which we use for novelty determination, and the closest prior art which we use for determining inventive step. Inventive step, I said, is a difficult task to determine because comparative test is not to be adopted here. The third criteria we discussed was industrial applicability. In industrial applicability, we saw that industry is defined in a broad sense to include even agriculture. Industrial applicability requirement is fulfilled whether you are in a position to use it in industry or whether it can be manufactured by industrial process. But there must be clear, concrete, immediate benefit of the invention which you must disclose. I said it is very important in the context of method of treatment. Because of this criteria, method of treatment of humans and animals is not granted patent. And I also said large number of biological inventions do not get patent on the ground that they do not fulfill the requirement of industrial applicability. Towards the end, I said that before you examine the patentability, the first task for patent office is to see whether the invention consists of subject matter which is patentable. That is to decide the eligibility of that invention, patent eligibility. So in the present session, we will talk about those things which are not considered as invention according to Patent Act 1970. We will mainly talk about section 3 and also section 4 of Patent Act 1970. So let's start our discussion on what are not inventions. You see, the type of subject matter that should be patentable is a very conflicting issue. It generates a lot of conflict and uncertainty. Primarily because patent offices are not aware of the technologies which are brought for patenting. Because all these technologies are new technologies. So therefore, patent office is yet to understand these technologies, and that is the reason why whether it is eligible for patent or not is always an uncertain question. I have already mentioned that invention must not be an abstract thing. Invention must be concrete. Invention must be physical. It must result from human intervention into nature. Nature into nature is no invention. Man into nature may become invention. So it must be concrete. It must be a physical thing. There are factors which limit the list of subject matter which are patentable. First, we have already discussed the invention must be capable of industrial application. This is a very serious limitation on the things which are patentable. We have discussed this point. Second, patent shall not be granted on immoral inventions. The inventions, the working of which will lead to immorality, such inventions cannot be granted patent. We will talk about it in this session. And the last, in our Patent Act 1970, we have a list of things which are not regarded as inventions in the first place. So we will basically talk about these two things in this session. What are the list of things which are not regarded as inventions? Section 3, we will also talk about 4, and patent shall not be granted for immoral inventions. How do we decide immorality of the invention is something which we will talk about in this lecture. Let's talk about excluded subject matter first, section 3. And if you go through the list which is there in section 3, it is not difficult to identify that almost all of these exclusions are very obvious exclusions. These exclusions are because these are very abstract inventions. Except for the exclusion of computer program, no other exclusion is something which is difficult to understand, because all of these are what? Abstract things which cannot be granted patent. But why computer program is excluded, that will be discussed. Probably because if you recall, while discussing copyright law, I said computer program is protected under the definition of literary work in section 2(o) of Copyright Act 1957. A literary work includes computer program includes its source code, its object code. Because it is considered to be sufficiently protected there, we thought let's not protect it in Patent Act. But then there are problems. The protection in copyright, I did not talk about it in detail. But if you recall, I refer to the case of Computer Associates versus Altai, in which we talked about the test called as AFC test, abstraction filtration comparison. The argument against that test is the test does not give sufficient protection to computer program. The functional aspect of computer program remains unprotected under copyright law, and therefore there are attempts made by the inventors to claim protection on computer program under Patent Act. We'll talk about it later on. The first thing is how to determine whether the invention falls in section 3 or not. How to determine whether invention falls in the list of excluded subject matter or not. If the invention has aspects which are patentable as well as non-patentable, if you think that is a mixture of patentable and non-patentable invention, non-patentable elements. See, we are trying to understand whether the invention is excluded from patenting by virtue of section 3. How do we decide it? First, we will have to interpret the invention. And how do we interpret the invention? If the invention consists of patentable and non-patentable elements, then whole content approach is to be adopted. Look at the invention as a whole, and let's not dissect the invention into patentable and non-patentable parts. We will look at the invention as a whole to see whether it can be patented or not. Court will not make an attempt to identify the essential nature of the invention. So we will not identify which part is essential, therefore give patent to that part. No, that will not be the approach. The approach will be to see the effect of the invention upon the prior art. What the invention does, this is the key word. Instead of looking at the various parts of the invention to decide which part is patentable or not, whole content approach is to be adopted. Look at the invention as a whole and see what is the effect of that invention, what that invention does. And on the basis of that, we will decide whether it is falling within section 3 or not. Let's quickly rush through the list which you have in section 3. Out of all these entries, I will talk about some of the entries in a bit detail. Section 3A says frivolous inventions are not patentable, or inventions against natural law are not patentable. For example, in the previous lecture I said compilation of already existing articles. You attached a torch with a gun, put on the torch and say that it works in dark also. This is not patentable, it is frivolous. There is no interrelationship between the two articles, and therefore such inventions are frivolous inventions. No patent shall be granted. So first point is frivolous inventions are not patentable. You also have this thing, inventions against natural laws. So therefore I am claiming that I have made a perpetual motion machine which will give you output without input. Court, the patent office will not look into such an invention. It is against natural law. Section 3B says any invention which is contrary to public order or morality. We'll talk about immoral inventions in detail later on. Or which is prejudicial to life or which is harmful to environment cannot be patented. A machine which is used to pollute environment can never be granted patent. An immoral invention can never be granted patent. For example, I have invented a syringe which can be used to inject opium into human body for better absorption. This is an immoral invention. So immoral inventions, inventions which are against public order, inventions which are prejudicial to life or environment, all these are not patentable under section 3B. And as I said, I will talk more about the immoral inventions later on in this lecture itself. 3C says scientific principles, abstract theories and mere discoveries are not patentable. We will talk about this aspect later on. Mere discoveries are not patentable. Scientific principles, abstract theory, for example, theory of equilibrium cannot be patented. The three theories of gravitation cannot be patented. These were there in nature, you only discovered them. These cannot be patented. But we will talk more about mere discoveries later on. 3D is particularly important in the context of Indian drug market, R&D related to drugs and medicines. Section 3D says a new form of a known substance is not patentable. Discovering a new property of a known substance is not patentable. And new use of known substance is not patentable. If you recall, I mentioned in the previous class that novelty of use is not considered as sufficient novelty for granting patent. I gave you the example of aspirin. It was invented for some purpose. Later on, somebody discovered that it can be used for some other purpose also. That was not sufficient and patent will not be granted. So therefore, new form of a known substance, new property of a known substance, discovery of new use of a known substance, these are not patentable. I will particularly discuss about new form claims. This is very important in the context of drug industry, as I said. Point number 5, mere admixture resulting into aggregation of properties. You take paracetamol, you take ibuprofen, combine these two, make a drug, claim patent on this new drug? No, it is just a mere admixture where the result is nothing but aggregation of properties. Paracetamol will work in its own way, ibuprofen will work in its own way. Such mere admixtures are not patentable. But it may be noted here that if the mixture produces a new result because of the synergistic effect of the two components. For example, drug A and drug B, when combined, produce a result which neither A produces nor B produces in isolation. So if because of synergistic effect of the properties of the constituents of that drug, a new result is produced, it becomes a subject matter of patenting. So keep in mind, mere admixture, which is nothing but aggregation of properties, is not patentable. However, if that admixture because of synergistic effect of the components produce a new result, it may be the subject matter of patenting. Then you have section 3F. It is again similar to what we have already discussed. Vishwanath Prasad Radheshyam case in the previous lecture, I said known integers are combined producing no new result is not patentable. It is mere a workshop improvement. Mere arrangement or rearrangement of devices, you can see section 3F, it says mere arrangement or rearrangement of devices is not patentable. It is only a workshop improvement. Changing the thickness of a bag so as to carry heavy loads is only a workshop improvement. So mere compilation of known devices, each device functioning in its own known way, the result is not patentable. But we also said that if because of interdependence or interrelationship between the constituent parts, a new result is produced, then the combination can be patentable. I gave you that example. There is a pen, there is a torch attached, put on the torch, start writing in the dark. That is not patentable. It is mere rearrangement. But if I have created a pen, when the nib hits the page, the light glows. There is interrelationship. This device can be patented because it is more than mere rearrangement of devices. Then you have section 3H, which says any method of agriculture, any method of horticulture is not patentable. I have invented a method of increasing yield by maintaining moisture level in the soil. I cannot claim patent on this method of increasing yield because it is only a method of agriculture. Then you have method of medical treatment. We'll talk more about it. You recall I said while discussing industrial applicability, I said method of treatment of humans and animals is not considered to be industrially applicable, useful. It fails industrial applicability. So it is not patentable because of two reasons. One, it does not pass the requirement of industrial applicability, and second, it is one of the exclusions in section 3. Section 3I says that method of medical treatment is not an invention. So there are two reasons why it is excluded. We'll talk more about it. You have section 3J, which says plants are not patentable, animals are not patentable. We'll talk about it again. Mathematical algorithms are not patentable. Algorithms are natural. You only discover them. Mere computer program is not patentable. We'll talk more about this part. Copyrightable works are not patentable. Presentations are not patentable. Even the best presentation on patent law will not be given patent protection. Mental acts, method of playing games, these are not patentable subject matter, section 3M. For example, you invent a method of remembering names. Law students will have to remember names of many cases. They may invent methods of remembering names of those cases, but those methods are not patentable. These are only mental acts. Integrated circuit is not a protected subject matter in Patent Act. We have a separate law for protection of semiconductor integrated circuit layout design. The name of this act is Semiconductor Integrated Circuit Layout Design Act. Why don't we grant protection to semiconductor integrated circuits in patent? These are inventions. Why do we call them as something other than invention? There is a different reason for that. I said patent is a limited monopoly, and in return the inventor will have to disclose his invention. In an IC, in an integrated circuit, there are billions of transistors, and if you start disclosing or describing those billions of transistors, the description will run into tens and thousands of pages. So therefore it becomes difficult for the inventor to fulfill the requirement of enabling disclosure, which we discussed in the previous class. You have to disclose your invention in an enabling manner. Therefore this has been removed from patent law and has been given protection under a separate act where the requirement of description is not that rigid as we have in Patent Act. Traditional knowledge is not patentable, so you cannot claim patent on healing effect of turmeric. Although at one point of time American Patent Office granted it, it has now been revoked. So traditional knowledge belongs to all, it cannot be patented. We had some problems, traditional knowledge was not codified, so when Americans were granting patent on something which belonged to traditional knowledge of India, they had no ready reference and therefore patent was granted. Now we have prepared Traditional Knowledge Digital Library TKDL, and now TKDL in digital form is available, and every patent office before granting patent will also look into TKDL when they are examining novelty of the invention. And now we can say that the traditional knowledge is safe and nobody may misappropriate the traditional knowledge. Section 4 says, for the purpose of national security, inventions related to atomic energy will not be the subject matter of patent. So this is the list of things which are not patentable: frivolous inventions, inventions which are contrary to public order, morality, scientific principles, abstract theories, mere discoveries, new form, new property, new use, mere admixture, mere arrangement, rearrangement, method of agriculture, method of medical treatment, plants, animals, mere computer program, presentations, copyrightable works, mental acts, integrated circuits, traditional knowledge and inventions related to atomic energy. Now, out of this, I said I will be discussing about some of these in a bit detail. These are those areas where we get applications. The first is mere discovery is not patentable. And this is important in the context of advances in genetics. Recently, there are advances in the area of genetics, and now attempts are made to get patent on the inventions done in the field of genetics. But it depends on this question as to whether the subject matter which has come for protection is an invention or a mere discovery. An invention, as I have been saying, is a practical thing, is a practical product or process. It is not just an information about the natural world. And I also said that utility is a very important criteria in case of biological subject matter, if you recall. Now, so invention is a practical product or process. It is not just an insight into natural world. It is not just an information about natural world. If on the basis of the discovery you can tell people how it can be usefully employed, a patentable invention may result. So, a discovery, if it can be usefully employed, it may still become the subject matter of patent. In relation to biological subject matter, the right question is not to ask whether it is living or non-living. Whether the invention is a living thing or non-living thing, that is not the right question. The right question is whether it is man-made or product of nature. If it is man-made, even if the subject matter is living, it can still be granted patent. Calcutta High Court in the year 2002 decided a case called as Diminaco AG versus Controller of Patents. I said it is not important or relevant to ask whether the subject matter is living or non-living. Living things can also be granted patent. When for the first time in 1980s, American Supreme Court got a case in which patent was claimed on genetically modified bacteria, the first question was, how can you grant patent on life form? But court said, no, anything under the sun which is man-made is patentable. The right question is not whether it is living or non-living. The right question is whether it is man-made or product of nature. In Diminaco AG versus Controller of Patents, Calcutta High Court adopted the same approach and evolved a test called as vendibility test. Court says if the end product is commercial, if the end product is vendible, the presence of living organism is no bar to patentability. So let's be very clear that life forms can be granted patent. What is important is whether there is commercial utility, whether the end product is a vendible product or not, whether it is a man-made product or not. How to distinguish invention from discovery? There are 3 points you see here. If a process is developed that enables a substance found in nature to be isolated and obtained from its surrounding, the process is patentable. So, it is a naturally occurring substance and you have developed a process to isolate that naturally occurring substance from its surroundings without losing its properties, then that process is patentable. It is invention. Second, the finding of substance freely occurring in nature is a mere discovery. You locate a gene inside the human body is only a discovery. It is same as locating a 5,000-year-old mummy. It remains discovery. Discovering moon is discovery. Discovering a gene, a nucleotide inside the human body is nothing but discovery. There are two situations when something patentable comes into existence. One, you develop a process which enables that substance to be extracted from its natural habitat. That process is patentable. Second, the natural substance that has been isolated, if that is characterized by way of its structure, by the process by which it is obtained, or by other parameters, substance per se may become patentable. So, there are two situations when something discovered may become patentable subject matter. One, a process patent can be claimed if you develop a process to isolate a naturally occurring substance from its habitat. Second, when the isolated thing can be characterized on the basis of some properties, that isolated thing per se can also be granted patent protection. So, these are some of the tools to understand how to distinguish invention from discovery. So, in relation to discoveries, mere discoveries, we now understand that we have to understand whether the subject matter is mere discovery or invention. I gave you a few points. The practical utility of the invention is very important, because in case of biological subject matter, in most of the cases the invention fails to get patent on the ground that it does not pass the requirement of utility, the requirement of industrial applicability. I said, if on the basis of discovery you can tell people how it can be usefully employed, then it may become a patentable subject matter. I said we have to understand that right question is not to ask whether it is living or non-living. Therefore, living things are very much patentable as long as you can prove that this is not product of nature, this is man-made. In order to distinguish discovery from invention, I gave you 3 points. Locating human gene inside the body is mere discovery. If you develop a process to extract it from human body, it may become patentable process. And if that gene can be characterized and it can be made useful, then that gene itself can be patented. So, that is about mere discoveries. Now, let us go on to the next point, computer related inventions. I mentioned it in section 3K. Section 3K says mere computer program is not patentable. And I also said that this exclusion was based on the understanding that computer programs are sufficiently protected in copyright law. But we understand that AFC test, the abstraction, filtration, comparison test, is not sufficiently protecting the functional aspect of computer program, because you recall we said only the relevant labor, the part which is the result of relevant labor, will get protection. If computer program is a literary work, only that part which is the result of application of literary labor will get protection. So, any part which is the result of application of artistic labor, that is the overall architecture of the computer program, the structure of the computer program, in which much of functionality resides, will not get protection under copyright. So, therefore, there have been attempts by the inventors to claim patent protection, and large number of patents are granted in a routine manner on inventions related to computer program. Let us see about it. There is an approach called as whole content approach. It says that invention which included a computer program could be patentable so long as the invention as a whole is technical. So, you will not exclude an invention from patenting on the ground that it includes a computer program which otherwise is a technical invention. Now, with the adoption of this whole content approach, the door for patenting of computer programs opened. We have a case called as Vicom Computer Related Invention 1987. It says an invention which is otherwise patentable should not be denied patent on the ground that for its implementation a computer program is required. So, therefore, this is something in line with whole content approach. An invention which is otherwise patentable cannot be denied patent on the ground that for its working computer program is required. So, what I am trying to say, computer program as such is not getting patent by virtue of whole content approach. The computer program is getting protection by including it in some other invention, as a part of some other invention. There is another case of 1997 called as Fujitsu's application. This is a case in which somebody developed a computer program that developed chemists to produce digital models of hybrid chemicals. Now, it is possible to make three-dimensional models of compounds. Scientists do it when they present things in exhibition. It is possible to make three-dimensional models of hybrid compounds. What this computer program does, it makes the whole process more efficient. Now, court says this is not patentable because it is doing something which in any case would have been done by the scientists. So, such a computer program is an ordinary computer program used in a general purpose computer, and this is not patentable. So, we are moving ahead of whole content approach. One thing is clear, that computer program as part of a larger invention which is otherwise patentable will get protection. We have understood that. Viacom computer related inventions clarified that as part of a larger invention, a computer program also gets protection. Now, in Fujitsu application, we tried to see whether the computer program as such can be patented. Court said no, this is not a kind of computer program. So, in Fujitsu's application, patent was denied on the ground that it is an ordinary computer program used in a general purpose computer, and therefore it is not patentable. You see, the language of section 3K suggests that legislature did not want to exclude all computer programs from patentability, because section 3K, which excludes computer program, says that computer program per se is not patentable. When it says computer program per se or computer program as such is not patentable, it means that otherwise it is patentable. So, that is how inventors interpreted it. So, instead of claiming protection on computer program as such, as we saw, it can be claimed as part of a larger invention. Subsequently, the understanding changes. The meaning of computer program per se is not the computer program alone. Meaning of computer program now becomes a computer program which is not abstract. So, what is not patentable is any computer program which is abstract or lacking in technical character. So, therefore, the law changes. From whole content approach, we move to a situation. We have many cases. I have not referred to those cases here. Aerotel in England, we have cases in USA. The approach shifts from whole content approach to the approach of technical effect. So, any computer program which is not a routine computer program, an ordinary program for a computer, any computer program which has technical effect is patentable. Any computer program which provides technical contribution to the prior art is patentable. So, that is how the law is moving ahead. You see, while examining the technical effect, what do we actually see? We see the effect deriving from the execution of the instruction given by the program. So, program gives an instruction to the hardware, and what is the effect of that execution of that instruction? If the effect has technical character, or if the effect causes the software to solve a technical problem, then computer program is not computer program per se, it is other than this. So, program gives an instruction to the hardware, as a result of which some effect is produced. If that effect is technical in nature, or if that effect solves a technical problem, then the computer program is not a computer program per se, and therefore it is patentable. This is what we had in our Indian CRI guidelines of 2015, and again in 2017 we had this principle. These are guidelines for computer related inventions of the Indian Patent Office, in which we included the requirement of technical effect or technical contribution to prior art. There is one more thing which I need to mention here is, there is one more approach called as any hardware approach. Any hardware approach will say that a program is protectable if it comes with a novel hardware. This requirement, this test was there in 2016 CRI guidelines, which is replaced by 2017 guideline because it was opposed. It was opposed by the software industry in India. Because you cannot expect every programmer to develop a hardware, a new hardware, in order to claim protection for his software. So that was going against the interest of inventors. In India, we are giving importance to startups. Most of the startups are software-based startups. Many small and medium enterprises are software-based enterprises. They express their inability to invent a hardware always with a software, and therefore this guideline was opposed. And as a result of opposition, we came out with a new guideline going back to the requirement of technical effect and technical contribution. So today, what is the law? The law is any computer program which produces technical effects, any computer program which leads to technical contribution to prior art, any computer program which comes along with a novel hardware, all these are other than computer program per se, and these are patentable. So that is the story of patentability of computer related inventions or patentability of computer programs. The next subject matter which I will discuss is biological subject matter. Biological subject matter, it is excluded from patenting. What is excluded? Variety of animal is excluded, variety of plant is excluded, an essentially biological process for production of animal and plant is excluded. So there are three clear exclusions here. Variety of animal is excluded, variety of plant is excluded, and essentially biological process for production of animal or plant is excluded. There is a case popularly known as Harvard Onco mouse case, in which scientists of Harvard University came out with a genetically modified mouse which had the disease of cancer. This disease was caused by genetic modification. Initially, when patent was claimed on Onco mouse, Harvard Onco mouse, in various patent offices it was opposed on the ground that mouse is a high life form and patent must not be granted. It is not a bacteria, it is a high life form and therefore patent must not be granted. The claim was on genetically modified non-human mammal. And eventually the courts, the patent offices held that animals are potentially patentable. Although we have an example of variety of animal, an animal variety cannot be patented, but what patent offices have concluded? Mainly in relation to this case, Harvard Onco mouse decision. Animals are potentially patentable so long as the patent application does not attempt to patent an animal variety. So in this case, the claim was not on the variety of animal. The claim was not on patent to be granted on mouse. It was a claim on the genetically modified mouse called as Onco mouse. It was held that animals are potentially patentable so long as the applicant is not claiming patent on a variety of animal. It was also held that an invention relating to an animal may be patentable. An invention relating to animal may be patentable so long as the technical aspect of the invention does not reside in particular animal variety. So an invention related to animal is patentable, potentially patentable. What you have to prove is that the technical aspect which I have in this Onco mouse, the technical aspect which I have in this Onco mouse, which is genetic modification, is not present generally in any animal variety. So what makes your mouse patentable is the technical aspects inside that mouse which distinguishes it from any other variety of animal. So there are 2 points which I mentioned. One, animal is potentially patentable so long as the application does not attempt to patent an animal variety. And second statement, I said an invention relating to an animal may be patentable so long as the technical aspects of the invention does not reside in a particular animal variety. So that clarifies the position. As long as you are not claiming protection on variety of animal, an invention involving animal is very much patentable. The second exclusion is plant varieties. We will talk about it towards the end of our course. We will have a full lecture on protection of plant varieties and Farmers' Rights Act 2001. Because plant varieties are protected subject matter under a separate law. So therefore, protection is not granted under Patent Act. Article 27(3)(b) of TRIPS agreement says plant varieties may be protected by patent or may be protected by a sui generis law or may be protected by a combination of both. India prefers to protect new varieties of plant by way of a sui generis law, and therefore we have excluded it from the Patent Act. The third point is essentially biological process. The first point which you can see is what is excluded is essentially biological process. So it does not apply on products, because suppose the offsprings of onco mouse produced by the natural process of crossing also have the oncogenes. Does the protection on onco mouse extend to these offsprings also? It cannot be argued that these offsprings are the result of essentially biological process, so therefore no patent shall be granted on these offsprings. No. The exclusion is only limited to the process, not to the product of that process. So an essentially biological process may not be patented, but the product of that essentially biological process can very much be patented. So offsprings of an onco mouse containing the same oncogene is also included within the patent granted to Harvard onco mouse. It is possible, and it will not be excluded on the ground that it is a result of an essentially biological process. Why? Because the exclusion of essentially biological process is limited to the process itself. Suppose there is a process of 10 steps and one step is artificial, 9 are essential. One may argue that it no more remains essentially biological. It has become artificial. Does it become artificial only by one artificial step? The other extreme can be out of 10 steps, 9 are artificial, 1 is biological. Can you argue that still it remains biological? So how to decide whether a process is essentially biological? We will have to see the overall, the degree of human intervention. If there is trivial human intervention, that will not change the nature of that process. It remains essentially biological. We are not talking about purely biological. We are talking about essentially biological process. So trivial intervention will not change the nature. So that is how we will have to see the human intervention. The impact of human intervention is to be seen to decide whether the process in question is an essentially biological process. The next exclusion is method of treatment. Method of treatment, I have already mentioned, is excluded because of 2 reasons. It lacks industrial applicability, and second reason is it falls in section 3. This is an important statement. You can read this. Invention of method of treatment of human or animal body by surgery, therapy or of diagnosis practiced on the human or animal body is excluded. What is excluded? Method of treatment by surgery, by therapy, by diagnosis, which is performed on human body, performed on animal body, that is excluded. And what is excluded? Let me again highlight, the method is excluded. So method of surgery is excluded, surgical tools are patentable. Method of therapy is excluded, drugs are patentable. Method of diagnosis is excluded, diagnostic kits are patentable. How do we decide whether the method in question is method of treatment? We will have to see the effect of that method and compare it with surgery, therapy, diagnosis. If that method produces result similar to surgery, it is method of treatment. If the method produces a result similar to therapy, it is method of treatment. And therefore, we need to understand the definition of these three terms. Surgery is branch of medicine concerned with the healing of disease, accidental injury or bodily defects by operating on the living body. Therapy is treatment with a view to maintain health. It includes curative treatment also. In case of therapy, we need to see the purpose, because there are many diseases which are cured because of therapeutic reasons, and you have cosmetic reasons also. For example, cleaning plaque or weight loss. Weight loss is done by therapeutic methods for therapeutic purposes because obesity is a disease. Weight loss is done for cosmetic reasons also. You have clinics where you do weight loss trainings. Whether the method invented is a method of treatment, method of therapy or not, we'll have to see the object of that or the purpose of that method. If the purpose is therapeutic, it is not patentable. If the purpose is cosmetic, it is patentable. Cleaning plaque is another example. If the method is therapeutic, it is not patentable. If the method is cosmetic, it may be patentable. There may be a method invented which will have both the purposes. In that case, we will have to see the dominant purpose. If the dominant purpose is therapy, then the method invented is not patentable. We have to be very careful while deciding whether it is excluded or not. Somebody invented a method of therapy for preventing pregnancy from occurring, and patent was claimed, initially denied on the ground that it is method of therapy, but finally it was decided that pregnancy is not a disease. So a method to prevent pregnancy from occurring cannot be a method of treatment because it is not treating any disease. So in therapy, one has to be careful in understanding whether it is an excluded subject matter or not. Diagnosis can be defined as those methods whose results make it possible to decide on a particular course of medical treatment. So these are the excluded subject matter. One has to see whether it is surgery, the effect of the method is same as surgery, therapy and diagnosis before deciding whether it is excluded or not. Now let's go on to the next point. New form, new property, new uses. It is there in section 3D. You have to read this part carefully. It says the mere discovery of new form of a known substance which does not result in enhancement of the known efficacy of that substance, or the mere discovery of any new property, or the new use of a known substance, or of the mere use of a known process, result, machine or apparatus, unless such known process results in a new product or employs at least one new reactant. I am concerned with these. Mere discovery of what? New form of a known substance. Mere discovery of what? A new property of a known substance. Mere discovery of new use of a known substance. I am concerned with these three. 1, 2, 3. Now you see, I have already mentioned that new use claims are not allowed. But if you look at this paragraph carefully, new use claims are absolutely prohibited. New use claims, novelty of use of a known substance is not at all novelty, it is not acceptable. Similarly, discovery of new property of a known substance is absolutely prohibited. In no case it can be granted patent. It is the discovery of new form of a known substance, that is also not patentable. However, if in its new form it results in enhancement of known efficacy, you see I have written it in bold here, the new form of a known substance may be patentable if in its new form it produces enhancement of known efficacy. This is an area which was discussed in the Supreme Court of India in the case of Novartis AG versus Union of India. Novartis got US patent on imatinib mesylate, a compound, and all its salt forms in the year 1996. This is called as Zimmermann patent. It is so called on the name of the inventor. And the Novartis applied for drug approval. The brand name of drug was Gleevec. The active component of Gleevec was imatinib mesylate. Now in India in the year 1998, Novartis applied for patent on beta crystalline form of imatinib mesylate. Beta crystalline form is nothing but a new form of a known substance. We were not allowing product patent till 2005, but we allowed a mailbox system. Any person who wants to file a product patent application for drugs, food products, chemical compounds could file an application, but the application will be opened after 1st January 2005. That was the mechanism. When we opened the application, there were few oppositions already filed, and the patent was refused on the ground that it lacks novelty because it is nothing different from the patent claimed in USA. It is same as that. It is obvious, and most importantly, it is not granted patent because it is nothing but a new form of a known substance. The matter eventually comes to Supreme Court. Novartis claimed that imatinib mesylate in its beta crystalline form has better flow properties, has higher thermodynamic stability, has lower hygroscopicity. What Novartis is trying to do? Novartis is trying to prove enhancement of efficacy, but they gave this information about beta crystalline form in comparison to alpha crystalline form and not in comparison to imatinib in its pre-base. They also argued that in beta crystalline form, the bioavailability, the assimilability of the drug in human body increases, but they could not establish it by way of data. Now, court holds that these properties will not mean enhancement of efficacy. In case of drugs, enhancement of efficacy will mean enhancement of therapeutic efficacy, and that can be proved only if you can prove bioavailability or reduction in toxicity and removing side effects, etc. So therefore, patent was denied on the ground of section 3D. Court says the idea behind section 3D is to prevent evergreening. The inventors may keep coming out with new form and claim patent. That is not permissible. This is about new form. Now quickly in 2 minutes I will tell you about patent and immoral inventions. In Diamond versus Chakrabarti, for the first time in USA, patent was granted on life forms. TRIPS agreement says immoral invention must not be granted patent, but at the same time TRIPS agreement requires that if patent is refused on immoral invention, at the same time commercial working must also be stopped. Whether the invention is moral or immoral is to be decided on the basis of utilitarian balancing test, which came in the case of Oncomouse, in which court says that you have to do a cost benefit analysis. The benefit is that there is a likelihood of development of drug for cancer. The cost is sufferings of the animal and possibility of uncontrolled spread of unwanted gene. Now you balance these claims, and if the benefit outweighs the cost, then patent may be granted even to these inventions. So cost benefit analysis is to be done to decide whether the invention in a question is moral or immoral. We can have many cases and discussion on morality. What we discussed in this lecture, we discussed about patent eligibility. This discussion concludes our discussion on patent law. We'll talk about patent prosecution from next session. Keep in mind that there is an argument that patent law grants negative rights. It does not allow the patent holder to start manufacturing. It only allows patent holder to stop others from manufacturing. So why to have stringent criteria in Patent Act? Why to have the requirement of morality in Patent Act? Let us not have the requirement of morality in Patent Act. We can regulate the whole industry on the ground of morality under Drug and Cosmetics Act maybe. That is a regulatory law. So this is one line of argument which needs to be appreciated. I will take up this point again in the next lecture. So that concludes our discussion on patent law. The next session will be on procedure for grant of patent. From filing to grant, we will be discussing in the next session. That's all in section 3. Thank you very much for joining. Thank you.
Hello and welcome to this piece of literary snippet. Perhaps the most popular literary genre after novel is the short story. Sharp, compact narratives whose charm lies not only in what is said but also in what remains unsaid. Today I'll be reading one of the shortest instances of a short story that I have ever encountered, and indeed, the very charm of this particular story that I am going to read out today lies in the way it abruptly ends. It is an ancient tale from Mesopotamia which has been retold by several authors, among whom the name of Somerset Maugham stands out. The adaptation that I'll be reading out is perhaps the closest to the one that Maugham wrote. The story is titled, in all of its adaptations almost, as Appointment in Samarra. Here is the story. A merchant in Baghdad once sent one of his servants to the market. The servant was supposed to buy provisions for the merchant, but when he returned, he came back empty-handed. Indeed, the servant had all gone white, and trembling with fear, he told his master that he had met death in the marketplace. When I entered the market, the servant said to his master, I was jostled by a woman, and when I turned to look at her, I saw that she was death. I am very scared, master, because death looked at me with a threatening gesture. Can you please lend me your horse so that I can fly away from Baghdad to the town of Samarra and thereby escape death? The master, being a good man, gave his servant his best horse and saw him gallop off to Samarra to escape death. Then the master himself went to the marketplace and confronted death. Why did you make a threatening gesture to my servant? Asked the master to death. And death replied, it was not a threatening gesture. Rather, it was a start of surprise. I was astonished to see your servant here today, because this evening I have an appointment with him in Samarra. See you in the next episode of Literary Snippet.